If you possess a semi-automatic rifle platform, an AR-15, an AK-47, or any variant thereof, 9 specific jurisdictions are engineering a legal trap to convert you into a felon in the year 2026. We are discussing mandatory custodial sentences of 10 years and financial penalties exceeding $10,000 for simple possession. Some of these statutory prohibitions activate in a matter of weeks. If you are operating under the delusion that you are insulated from liability because you acquired your rifle legally years ago, you are gravely mistaken. Multiple states are systematically dismantling grandfathering protections, which means firearms you have legally maintained for decades are about to transform you into a criminal defendant. I am going to deconstruct the legislative strategy in all 9 states, identifying exactly what hardware is prescribed, the activation dates of these statutes, the criminal exposure, and the immediate tactical maneuvers you must execute to remain free. Here is the unvarnished reality. Ignorance of the penal code is not a valid defense strategy. If you are intercepted with a banned firearm subsequent to these effective dates, you are facing felony indictments, incarceration, and the permanent forfeiture of your Second Amendment rights. Let us begin with the 2 newest jurisdictions entering this prohibition matrix, as these are the ones catching responsible owners completely exposed. Number 1. Rhode Island. The grandfathering trap. Rhode Island has enacted one of the most draconian assault weapon bans in the Republic, and the enforcement window opens July 1, 2026. That is a 7-month countdown. This is not a vague regulation with loopholes. This is a total prohibition on the manufacture, sale, purchase, and transfer of what the state defines as assault weapons. What is the target? Any semi-automatic rifle with a detachable magazine that possesses a single military feature, a folding or telescoping stock, a pistol grip that protrudes conspicuously beneath the action, a bayonet mount, a flash suppressor, or a threaded barrel. The prohibition extends to semi-automatic shotguns with specific features or fixed magazines exceeding 5 rounds. Here is the severity of the threat. The penalty structure mandates up to 10 years in prison and a $10,000 fine. This is a felony conviction. It equates to the loss of voting rights, the permanent stripping of firearms ownership rights, and a criminal record that destroys employment and housing prospects. Now, Rhode Island claims to offer grandfathering, but it is a legal straitjacket. If you lawfully possess these firearms prior to July 1, 2026, you retain ownership, but your rights are effectively terminated. You are restricted to possessing that asset solely at your domicile, your place of business, on freehold land you own, or at a licensed range. You cannot carry it anywhere else. You cannot sell it to a resident. You cannot transfer it. You cannot bequeath it to your heirs unless they reside out of state. The only legal exit ramps are transfer through a federal firearms licensee, FFL, to an out-of-state entity or surrender to law enforcement. If you relocate to Rhode Island post-July 1, 2026, your grandfathered weapons are contraband the moment they cross the border. Action plan for Rhode Island. First, conduct an immediate inventory of every semi-automatic asset. Cross-reference against the banned features list. Understand that post-July 1st, your possession is functionally house arrest for the firearm. No hunting on public land, no informal shooting, no lending. Any possession outside authorized zones is a felony. If you intend to remain in Rhode Island, evaluate whether a firearm you can barely legally move is worth the liability. Your strategic alternative is liquidation to a free state buyer before the deadline or transfer to out-of-state family. Number 2, Colorado. The bureaucratic blockade. Colorado is the second state activating major restrictions in 2026. This has blindsided owners because the state has historically been permissive. Here is the legislative trick. Colorado is not banning the weapon, they are banning the transaction. Effective August 1, 2026, the state mandates a firearm safety course eligibility card for any individual attempting to acquire a semi-automatic firearm with a detachable magazine. This is a critical distinction. If you possess the hardware prior to August 1, 2026, you are exempt. There is no registration, no surrender, no restricted movement. Your existing inventory is secure. However, the acquisition process post-August 1st is designed to be an insurmountable barrier. You must complete a state-sanctioned course involving live fire, legal indoctrination, and storage protocols. You must clear a background check just to obtain the card. The card requires a fee. The course requires a fee. The card expires in 5 years. Even with the card, you face the standard federal background check and a statutory 3-day waiting period. They are engineering weeks of delay to purchase a single defensive tool. Furthermore, Colorado is closing the private sale loop. As of August 1st, 2026, all private party transfers of semi-automatic firearms must route through a licensed dealer. The days of selling to a neighbor or gifting to an adult child without a federal paper trail are over. Violations start as a Class 2 misdemeanor, but escalate to felonies for repeat offenses. Action plan for Colorado. If you intend to acquire semi-automatic platforms, execute those transactions before August 1st, 2026. Post date, you are voluntarily entering a bureaucratic nightmare. If you already own them, maintain possession. But for future private sales, recognize that every transfer requires an FFL and a background check. Document your inventory now to establish a chain of custody proving ownership prior to the new regime. Number 3. California. The convertible pistol trap. California operates the most restrictive framework in the nation, yet they are tightening the screws effective July 1st, 2026. Assembly Bill 1127 specifically targets semi-automatic pistols that can be converted to fire automatically. This language sounds targeted, but it is a broad net designed to capture standard firearms. The statute bans dealers from retailing any pistol that can be converted without the replacement of major component parts. The Attorney General is granted the authority to determine which pistols fit this nebulous definition, and they are publishing a blacklist. For dealers, the fines are $10,000 per violation. For you, the gun owner, this means the already microscopic roster of handguns certified for sale is about to evaporate. If you own pistols that land on this ban list, you fall under existing grandfathering protocols. You keep them, but you cannot transfer them within the state. Your market value drops to zero inside California borders. Action plan. You must monitor the Attorney General's website post-January 2026. If your models are flagged for the ban list and you intend to liquidate, you must execute the sale prior to July 1st, 2026. After that date, your asset is frozen. Now, we transition to the 6 jurisdictions operating under existing prohibitions, where the 2026 strategy shifts from legislation to aggressive, funded enforcement. Number 4. New York. The SAFE Act resurrection. The NY SAFE Act has been the operational framework since 2013, but 2026 marks the weaponization of its enforcement arm. The state legislature has injected an additional $15 million specifically for assault weapon compliance teams. This is not administrative overhead. This is funding for investigators, prosecutorial resources, and door-to-door verification. Under the statute, possession of any semi-automatic rifle with a detachable magazine and a single military feature, pistol grip, thumbhole stock, bayonet lug, muzzle device, is a Class D felony carrying 7 years in state prison. Here is the 2026 trap, the re-registration purge. New York is implementing a digital migration for the grandfathered assault weapon registry. If you complied with the law in 2013 and registered your weapon, that data is now considered legacy. You are mandated to re-register in the new centralized system by June 30th, 2026. Failure to execute this administrative action converts your previously legal, grandfathered firearm into contraband overnight. The state is not issuing individual notifications. They are relying on your negligence. If you miss the deadline, you are a felon in possession of an unregistered assault weapon. Action plan. Audit your status immediately. If you hold a 2013 registration, you must validate it in the 2026 portal. Silence from the state is not safety. It is a trap. Number 5. New Jersey. The substantially identical dragnet. New Jersey has maintained a ban since 1990, but their mechanism of control is unique and insidious. They ban specific firearms by name, but they also ban anything substantially identical to those named weapons. For decades, this definition was the gray area where legal ownership existed. In 2026, the Attorney General is closing that gap. They are bypassing the legislature and expanding the substantially identical administrative list. This is a direct threat to owners of compliance rifles. You purchased a rifle that was engineered to be legal. In early 2026, the AG will publish a new roster of copycat weapons. Dozens of models previously considered compliant will be retroactively defined as banned assault firearms. New Jersey does not grandfather newly banned copycats. Once that list is published, your possession is a crime of the 3rd degree, 3 to 5 years in prison, and a $15,000 penalty. Action plan. You must maintain daily surveillance on the NJ Attorney General's guidance in January 2026. If your model appears on the expansion list, the window for removal is nearly non-existent. You must transfer out of state or surrender immediately. There is no grace period for "I didn't know." Number 6. Massachusetts. The featureless fallacy. Massachusetts is executing the most aggressive interpretation of copycat statutes in the nation. Under their code, it is illegal to possess a copy or duplicate of a banned weapon. Historically, manufacturers navigated this by removing features, the feature-compliant AR-15. In 2026, the Attorney General is launching a compliance crackdown that declares these modifications irrelevant. The new enforcement standard asserts, if the rifle operates similarly, shares design lineage, and fires the same caliber, it is a copy, regardless of whether it has a pistol grip or a flash suppressor. This reinterpretation instantly criminalizes thousands of owners who purchased Massachusetts-compliant rifles from licensed dealers. The state's position is that those rifles were never legal. They were simply not prosecuted yet. The penalty is a felony with mandatory minimum sentencing, 1 year for the first offense, 5 years for the second. Action plan. Do not rely on the assurances of the gun store clerk who sold it to you. Do not rely on internet forums. Consult a specialized Massachusetts firearms attorney immediately. If your rifle is an AR or AK platform, you are likely in the crosshairs of this 2026 enforcement wave. Your options are modification to a fixed magazine configuration, if even that is accepted, export out of state, or surrender. Number 7. Connecticut. The retroactive data audit. Connecticut's ban dates to 2013, requiring registration of grandfathered assets. For a decade, that registry sat static. In 2026, the state is conducting the first comprehensive registration audit. They are cross-referencing the assault weapon registry against Federal Form 4473 purchase records and background check data. They are looking for the discrepancy. The gun you bought, but never registered. If you purchased an AR-15 prior to 2013 and failed to register it, the state now has the data analytics to identify that gap. They know you bought it, they know you didn't register it. This audit will generate search warrants. Furthermore, effective April 1, 2026, Connecticut mandates rigid storage protocols for all grandfathered assault weapons. They must be secured in a locked safe or disabled with a trigger lock whenever not in use. Violation is a criminal offense, separate from the possession charge. Action plan. Log into the State Police Special Licensing and Firearms Unit portal immediately. Verify your registration status. If you are unregistered, you are in immediate legal peril. Retain counsel. If you are registered, audit your physical security. Retain receipts for your safes and locks. They are your only defense against a storage charge. Number 8. Maryland, the blacklist expansion. Maryland operates under a specific tyranny, the named ban. Unlike states that rely solely on feature tests, Maryland prohibits specific firearms by make and model. In 2026, the state is weaponizing this list. Effective October 1, 2026, the Attorney General is adding 37 new firearms to the prohibited roster. These are primarily modern platforms released post-2013, including pistol-caliber carbines, PCCs, and AR-15 pistols equipped with stabilizing braces. The trap here is the 90-day confiscation window. Maryland does not grandfather newly banned weapons. Once a firearm is added to the roster, you have exactly 90 days to liquidate it out of state or surrender it to law enforcement. On day 91, possession becomes a crime punishable by 3 years in prison and a $5,000 fine. A second offense carries a mandatory 10-year sentence. Action plan. You must secure the updated prohibited list the moment it is published in July 2026. If your asset is named, you are on a clock. Locate an out-of-state FFL immediately. Do not wait until September. The transfer network will be saturated. If you possess a PCC or a braced pistol, assume you are a primary target. Number 9. Washington, the regulatory chokehold. Washington state has shifted tactics from outright bans to procedural disarmament. They are making the process of ownership so legally hazardous that they expect you to give up. 2 massive changes hit in 2026. First, the training mandate. Purchasing a semi-automatic rifle now requires a state-certified safety course, including live-fire training, valid for 5 years. No course, no purchase. This effectively freezes the market, while the state bottlenecks the number of approved instructors. Second, and more dangerous, is the criminal storage statute. Starting January 1, 2026, you are strictly liable for your firearms. If a semi-automatic rifle is stolen from your home because it was not in a locked safe or disabled with a trigger lock, and it is used in a crime, you are charged with community endangerment. You face jail time because a criminal stole your property. Furthermore, the red flag, RPO system has been expanded. Roommates and distant family members can now petition the court to seize your firearms based on concern, with a shockingly low burden of proof. Action plan. If you plan to acquire assets, complete the training in late 2025 to beat the bottleneck. Invest in commercial-grade safes immediately. A glass display cabinet is now a liability. Understand that your roommates are now potential state informants who can trigger a confiscation raid. The constitutional standoff. Why compliance is still mandatory. I know what you are thinking. These laws are unconstitutional. Under the Supreme Court's Bruen decision, you are likely correct. There is no historical tradition from 1791 banning semi-automatic rifles. The Fourth Circuit has already signaled hostility toward the Maryland ban. The Ninth Circuit is battling over California. Legal experts predict the Supreme Court will eventually strike these bans down, likely by 2027 or 2028. But here is the hard truth that could save your life. The Constitution is not a get-out-of-jail-free card. Until the Supreme Court issues a final ruling, these state laws are in full effect. Local police will arrest you. District attorneys will prosecute you. Judges will sentence you to prison. You cannot stand on the side of the road with an unregistered AR-15 and argue Bruen to a state trooper. You will be incarcerated while the legal battle drags on for years. Do not be the test case unless you are willing to lose your freedom, your fortune, and your family to prove a point. The strategic summary. If you reside in Rhode Island or Colorado, you have a tactical window until mid-2026. Use it to inventory, acquire, or divest. If you reside in California, New York, New Jersey, Massachusetts, Connecticut, Maryland, or Washington, the trap is already set or closing fast. Your priority is strictly compliance verification. Check your registration status. Audit your specific models against new copycat lists. Upgrade your physical storage security. Document every purchase receipt and transfer record. This is not about agreeing with the law. This is about survival. The state relies on your ignorance to generate felony convictions. Deny them that victory. Stay vigilant, stay legal, and most importantly, stay free.